Senate Bill 1381, an act concerning alternative treatment for serious diseases causing chronic pain and debilitating conditions. Third reading of the bill. Senator Haynes.
Thank you, Madam President, and I do appreciate very much your indulgence, the indulgence of the body. And let me give you a brief history of this bill. In 1937, there were many medicines containing marijuana which were available in the United States. In 1937, the Congress of the United States, in an omnibus drug bill, prohibited all marijuana for any purpose. Dr. Woodward of the American Medical Association testified actually against that bill, saying that there were many medical uses, beneficial uses of marijuana known to medicine even as early as the 30s. But in any case, the federal government lumped it in with all other deleterious substances such as cocaine and heroin and opium, and prohibited its use for any purpose. However, science literally marched on. Medical science found through many studies that marijuana was a beneficial use for some people in some circumstances. And we have outlined those in the bill, those suffering debilitating diseases with chronic pain. When I first started this bill, we began to run into people in all walks of life who came up to me with similar stories of being recommended to them by a physician or a next of kin to use marijuana. There was a court case, to hurry this along, there was a court case in the 1970s which actually ruled an administrative law judge that marijuana was found to be a medical use, and the prohibition of the use of it was arbitrary and capricious. However, FDA, the United States Congress, declined, or the drug and DEA, not FDA, DEA and the United States Congress refused to budge. However, the United States government did authorize, in response to this obvious scientific truth, a research program, and Illinois became a part of that. There were 26 states that applied for permission to use medical marijuana for research. However, this was a 1978 Illinois law. However, the federal government shut off the participation in the plan, and the people of Illinois were denied the opportunity to participate even in the research. But a landmark act was passed in Illinois allowing the use of marijuana, which is the law today in a medical research authorized by the United States government and the state. The state of Illinois, in response to our inquiry, the DHS has said they do not have such a program and do not foresee any. Hence the need for this bill. This bill, in its inception, allows the use in limited medical circumstances. In response to the concerns of law enforcement, we have substantively changed the bill and restricted it. We have restricted the number of plants to 3. We have prohibited the use of the operation of any motor vehicle by anyone who's in this plan. We have created penalties for the possession of plants that are actually greater than if people were not participating in the program. We have defined and delineated the diseases, all in response to some of the improvident things going on in California, because the California medical marijuana law was done by a referendum, and frankly it was sloppily drafted. We have learned from those mistakes, and we have crafted a very narrow bill. There's a requirement, as I've indicated earlier, for a physician-patient relationship. There's a delineation of a disease. There is strict control by the Department of Public Health over those who operate dispensaries. Those are places where marijuana plants can be grown and accessed by people who can't grow their own. These are all measures to avoid any imputation that this is a stealth legalization of marijuana. It is not intended to be a stealth legalization. It is a program that's enacted for the compassionate use by people who have been recommended by a doctor. There have been numerous studies, as I've indicated. I have in my possession a recent letter from a faculty member from the Washington University of St. Louis School of Medicine, one of the premier schools of medicine in the United States, in which he tells me he recommends marijuana. Dr. Clifford, many other physicians that I've spoken with have recommended this for their patients. In my own family, my wife's sister-in-law's brother died of esophageal cancer in Ohio 5 years ago. We were told 3 weeks ago that his physician recommended marijuana use because of the terrible pain and the inability to swallow. These are anecdotal, but these anecdotal pieces of evidence have accumulated across the country to such an extent that in every state, 13 states where this has been placed on the ballot, it has passed with overwhelming margins. The state of Michigan put it on the ballot. Last election cycle, it carried every county. It carried the Republican counties and the Democratic counties because of this anecdotal evidence and the obvious fact. I received a heart-rending letter from a retired physician of my hometown, the dean of the medical community. He's in his 80s. He's the former longtime president of the Madison County Medical Society. His name is Duvivier. He wrote me a personal note strongly approving of legalized marijuana use, and he appreciates all the efforts of those who are trying to do that. This is the science, and we have, last of all, to make this bill most restrictive and to avoid, again, any imputation that it's a legalization. We've made this a pilot program. It is only going to be for 3 years, and it sunsets. So if any problems manifest themselves in this bill, as a result of this bill, if it passes the House and His Excellency the Governor signs it into law, if any problems manifest themselves, we will not renew it, and I will not sponsor it. This is a partnership with law enforcement, I believe. I would never place burdens on my colleagues, my former colleagues, in the profession of the law, whether state's attorneys or police, but this is a reasonable application of discretion by a legislative body. It is speaking for the people of Illinois. It is saying that we have common sense and compassion.